I got a different document. It was adjourned to 5:23.
Okay, that's what I need.
Okay.
Thank you. All right, Ross. All right, the court calls case number 16-115-473. This is B Right Financial Services versus Tramiel Rush. The matter is before the court on an application for looks like a petition in order to show cause. Your appearance for B Right, please.
Timothy Frost on behalf of plaintiff B. Wright, Your Honor.
All right, and just state your P number if you will for the record, counsel.
40616.
All right, thank you, counsel. Do I have Mr. Tramiel Rush on the Zoom?
Yes, Your Honor.
All right, good morning to you, Mr. Rush. So have the two of you had an opportunity to talk, Mr. Frost? So I send you to a breakout room because it looks like the defendant is here. I know this was a.
Yes, just it would be helpful if you could put us in the breakout room, Your Honor, to speak a little bit.
Yeah, that makes sense. Mr. Rush, I'm going to give you a notification for breakout room to speak with Attorney Frost regarding this matter. It is an effort to collect regarding a judgment that was previously entered in this case. And then this is a petition for show cause to perhaps the issuance of a bench warrant. So let's talk through that and see if the matter might be resolved in some kind of way. And then click back in after you've had the discussion. So here's your notification for breakout room number 1. Counsel, I'm sending that to you as well, sir.
Very good. Thank you, Your Honor.
All right, the court now calls case number 22-177174. This is Estera Credit Union versus Robert B. Noted. The matter is before the court after the granting of an order for possession pending final judgment. The matter is before the court on the filing of a general civil complaint. The court did set this matter over for an adjourned date for review regarding this matter. Your appearance for the plaintiff in this matter, please.
Morning, Your Honor. May it please the court, Stephen Bequicchio, P 62076, on behalf of plaintiff Estera Credit Union.
Thank you, Mr. Bequicchio. Do I have to be Mr. Robert Lee Nolan or any counsel representing Mr. Nolan? If you're here, say something at this time.
Well, she could have paid her stuff with her 3,500. I don't know what you need.
There's a Galaxy 12. That's where all that noise is coming from.
I'm looking for Mr. Nolan.
Yes.
Is Mr. Nolan present? Is Mr. Nolan present?
Yes.
Is that Mr. Nolan that I see in the bed or laying down?
Yes. He in the hospital.
Oh, okay, thank you. Put the, let me see him. Good morning to you, Mr. Nolan.
Yeah.
Good morning, sir. Good morning to you.
Yeah.
Good morning.
Good morning.
Good morning, Mr. Nowden.
All right, thank you. Mr. Bequicchio, if you will, sir, talk to me, sir.
Thank you, Your Honor. My understanding is that Mr. Nowden or Miss Nowden has asked for the amount that is owed so that the nephew could pay for the vehicle in full. We've given that information to Miss Nowden to pass along, but have not yet received payment.
Right now, Ms. Nowden, Mr. Nowden, I did put you on mute because there was so much noise in the background. So Ms. Nowden, if you wish, just hit *6 on your device and that will unmute you. Just unmute yourself if you will. Just unmute yourself there, Ms. Nowden.
Okay.
All right, so the attorney on the other side, I know the last time that we were here, there was discussion about trying to resolve this with a payment, and you needed to have a final billing amount, what was owed to pay this off. I understand that you received that information, correct?
Yes, I got it last Thursday.
So I guess the question now is whether or not you're going to go ahead and resolve that, because court has already signed an order to take possession of the vehicle, but if that can be resolved, then that would solve some things. Shortly.
Well, I passed it along to his mother. So she said she passed it along to him. So I don't know what else to do after this,
Gotcha.
because he in and out the hospital. So I don't know what else to do.
All right, so when you say he's in and out of the hospital, you're not referring to the person that has the vehicle. You're referring to Mr. Nowden, correct?
Yeah. Yes.
All right, and I'm saying Nowden, I think it's Nowden, or whichever way it's pronounced. I don't intend to mess his name.
Pronounced Nowden or Noden.
All right, thank you, ma'am. All right, so counsel, the only thing that I see here is that I've granted the order to recover possession. Ma'am, I believe the last discussion, it was indicated that you had no idea where the person who possesses the vehicle is. You don't know where that person is, correct?
Yes.
So counsel, I've signed the order. Anything else at this point, sir?
Your Honor, at this point, no, with respect to possession of the vehicle, but we still have the legal right to a judgment here, and we've submitted a judgment. Your Honor's taken it under advisement as to whether to enter it. I don't think there are any legal grounds not to enter it at this time. I'm hopeful that the young man who's received the information will pay it. He's not under the jurisdiction of the court, Your Honor, except as to the possession of the vehicle. He is ordered as a affiliate of Mr. Nowden to turn over the vehicle under order of the court. And therefore, to the extent he knows about the order, and he's not turning it over or otherwise paying for it, Your Honor, we may have no other recourse but to bring him before the court to the extent we're able to serve him with the order.
Thank you, counsel. And I apologize. The noise that seems to the system. Are you able to hear me okay, Madam Reporter? I know it's a little difficult.
No, I can't hear you at all. So much noise. All of these people should be on mute. Thank you.
Yeah, well, it's only really coming from one place. I was trying not to do too much muting there because.
Okay, but thank you.
That's okay.
Okay.
Thank you. All right, so it appears to me that the court has already advanced this matter based upon the evidence and information provided to the court, and then I granted the order allowing for recovery of the vehicle pending final judgment in this matter. It does appear now on the motion of the plaintiff in this matter that there is no reasonable grounds of defense raised in this matter that is conceded that the vehicle is possessed by someone other than Mr. Nowden, although Mr. Nowden is the person who signed the obligation on the vehicle, and that the plaintiff is entitled to take possession of the vehicle. Moreover, where there's not a defense to the claim that has been asserted herein, the plaintiff would be entitled to final judgment with respect to this matter. And the court will sign a judgment consistent therewith upon its presentment to to the court. All right, so my order is to allow for repossession of the vehicle, and I will allow a judgment on the amounts that are owed at this time. Obviously, to the extent the vehicle is recovered and those amounts are reduced based upon the auction or sale of the vehicle, then the judgment would be reduced to correspond with the same. All right, that is my order at this time. And counsel, I know you'll submit an order consistent with the same.
Thank you, Your Honor.
Do you have the email address where you could send that, sir?
I believe. Okay. I can have if Your Honor would like to provide that to me, I'll have my assistant send that.
Let me give it to you again. That's Latifah, Latifah .Hunter at 36360 districtcourt.org.
Thank you, Your Honor.
All right, and that's my determination. Mr. Nowden, you'll receive a copy of the order of judgment in regard to this matter. I do wish you, ma'am, well, and Mr. Nowden, I hope you get better there. Good day to you.
Thank you. Get well, Mr. Nowden. Thank you.
All right, the court now calls case number 21-150013. This is Visiting Angels Living Assisting versus Kenneth Wesley. The matter is before the court on a date the court set on for review. The parties were attempting to reconcile some records and perhaps resolve this matter. Your appearance for the plaintiff in this matter, please.
You know, for the record, I'm Jim Washington. I represent the plaintiff, Visiting Angels in this matter. P42503.
All right, thank you, sir. Good morning to you. I'm looking now for Ms. Jefferson. Have you seen her this morning?
No, Judge, I spoke with her on Friday, but I have not seen her on board today so far.
All right. When you spoke with her, was there anything about whether or not she would be here today? Was that a part of the discussion?
Well, I had every indication to believe that she would be here because they did make a proposal, and I think that was in recognition of the day's date. So if you'd like, I can try to reach her.
Well, I know it's 5 minutes after the set time, so I can wait a bit on this. And if you would try to reach out, that would be helpful as well, sir.
I can do that, Judge.
And I'll circle back around to it shortly, sir. Thank you.
Very well, Judge. Very well.
All right, this is case number 21-341-547. This is Motor City Corporation versus King's Custom Incorporated. The matters before the court on the petition for reopening of this matter. Your appearance for the plaintiff, Motor City Corporation, please.
Good morning, Honorable Judge Lance Mason, P43926, appearing on behalf of the plaintiff, Motor City, the moving party. My clients are available as well.
All right, thank you, Mr. Mason, and good morning to you, sir. For defendant King's Custom Incorporated, your appearance at this time, counsel.
Good morning, Your Honor. Alan Applebaum appearing on behalf of the defendant, and I do see my client in the Zoom meeting.
All right, thank you, Mr. Applebaum. Mr. Applebaum, your P number for the record, sir.
36444.
All right, thank you. Thank you very much. All right, so I see that this was something that was in front of the Honorable Judge Demetria Brew, who took over my docket on landlord and tenant matters. And I see that she set it on for a hearing on today's date, and then it was sent over to me. So it looks like this is plaintiff's motion to reinstate the case. So Mr. Mason, tell me what's going on here, sir. if you will.
Yeah, Judge, with respectfully, one correction, you handled this matter back in October, Judge, and you wanted to keep specific jurisdiction over this case. Because of the unique facts of this case, you were able to reform a land contract between the parties who had initially been representing themselves before attorneys got involved. So what we have here, Mr. Appleball and I got directly involved, took control of the case, and with this court's indulgence and appreciation, of course, we were able to put an actual consent judgment on the record back in October. What the judge did for all the parties is we made a determination as to what the land contract, what was owed. We were very specific in that transcript about extending the writ because we're going back to October. So the original writ was extended by 90 days. The court was gracious enough to extend it a couple weeks to allow the defendant to make that final payment of about $14,000, which included some back taxes and things of that nature. He's failed to make that payment in January this year, Your Honor. Defendants failed to make the biggest payment and has actually been in this property, has paid nothing since January. And so I'm asking, basically, we were trying to, counsel and I were trying to put together a new agreement to kind of clear up some of the ambiguity in the original agreement. So we were not able to actually enter an order or a judgment of possession, but the consent judgment is on the record. And so what I'm asking this court respectfully to do is to enforce the consent judgment on the record that was entered back in October that gave the defendant up until January to make the necessary payment. He has not done so. He's actually been in his property for rent-free for the past 6 months. He has tenants on his property. Property taxes have not been paid. My client's still getting blight tickets on this property. So in essence, he's been in his property for a year and a half, basically, and has paid nominal money. So I'm asking the court just procedurally to allow to exercise its discretion to allow the judgment of possession to be enforceable as it exists on the consent judgment that was entered on the record on this matter, and to allow the plaintiff to have an immediate submit an application for an order of eviction in this case, because he's actually been in 90 days, even beyond January the 20th day. And that's the basis of my motion today.
Thank you, Mr. Mason. Mr. Mason, so the consent that was put on record was not ultimately reduced to writing, correct?
No, but the consent is in the record. I provided the transcript to the court with the language of the consent in it. That's correct. We were trying to work out the language for the judgment, but I have provided the court with the transcript with the unequivocal language, Judge.
Gotcha, sir. All right, Mr. Applebaum, sir.
Judge, yeah, the easy answer is that the consent that was placed on the record, it was a very meticulous consent that was placed on the record, was never memorialized in a judgment. I took a stab at drafting a judgment, and part of the judgment included a reworking of some material terms of the land contract, and we just never got to the point where we reduced that to writing. And the concern was, in the meantime, my client had made the interim payments that were required under the consent that was placed on the record. And we just figured, well, let's let it, assuming he makes the big payment was a balloon payment that was due on January 20th. And again, my client at the time we settled the case indicated to me he would be able to make that payment. So I figured, let's see if that payment gets made. If it gets made, then Mr. Mason and I then would be a little bit out of danger at that point and could spend a little more time memorializing the document. When he didn't make that payment, then kind of, everything kind of fell apart because A, he didn't make the payment. B, there's no court order in effect that in theory punishes him for not making that payment. So in theory, What I think Mr. Mason needs to do is, whether it's under the 7-day rule, whether it's filing a motion, whatever, he needs to memorialize that, at least the consent judgment, to show the dates and times of the amounts that were required to be paid. I know that my client didn't make the January payment. I'm not sure as a matter of law, if he made that payment tomorrow because the judgment hasn't been entered, would he be able to reinstate the land contract? I think that's a fight for another day. But I think Mr. Mason needs to at least file a motion to enter the judgment. He's got the transcript. He can either send it to me by consent as to form only, or he can file a motion to enter the judgment. But once the judgment's entered, then the parties will have certain rights that need to be followed. But I definitely admit that my client didn't make the January payment as was required. It was a $14,000 payment. I don't have it in front of me, but it was I'll call it a more significant payment than the December and the November and December payments of $2,000 that were required, which he did timely make.
All right, and there's no dispute that the balloon payment, if you will, was one that was in the nature of $14,000 and that it was due in January 2022, correct?
Correct. And then in the meantime, judges, I want the record to reflect that my client sent me a text that he thought he might want to replace me as his lawyer. So I've been hesitant to, file pleadings. I didn't file a motion to withdraw because I thought I would get a phone call from a lawyer substituting in for me. So I have some concerns in my continuing representation of my client, and he's here to tell. I think he may want to address the court, but I would make sure that if and when he addresses the court, that I don't want him to go back and re-argue whether the consent judgment was right or wrong. I mean, I know he agreed to it, but I think he may want to address the court. I really haven't talked to him in a few months, Your Honor, other than a text indicating he might want to get new counsel.
And may I briefly respond?
You're still a counsel of record at this time, and the court record speaks for the court's record, and we're not, that's something that that's something that is not going to change in any way. So to the best of your knowledge, the court record does in fact reflect that the payment in excess of $14,000 was due in January 2022. Is that correct, Mr. Applebaum?
Yes, Your Honor.
All right. Mr. Mason, obviously the court speaks to his written orders, and I have notes here. And the benefit of all of this is, of course, that there is a record. So first things first. First of all, on the motion to reinstate the matter, the court will grant the petition to reinstate the case for purpose of entry of the order, and the court will entertain the submission of an order consistent with the determination that was set forth on the record as a resolution of this matter. Now, essentially, the order submitted to this court, it only needs to, at this point, address the pertinent and central issues that pertain to this matter, and that is that the defendant apparently in this matter was ordered by virtue of the consent agreement to, in fact, pay a certain amount by January, and that has not been paid. The intent, of course, of this is that to the extent that was paid, that a deed would be forthcoming. But the other side of this is, of course, if the payment was not made, my notes indicate the defendant will vacate the unit within 30 days and has 10 days to surrender the keys. So,
Judge, I need to interrupt. That's not my client surrendering the keys. That's
I'll come back to you, Mr. Applebaum.
Okay.
I'll come back to you. Those are the notes that I have in regard to this matter. And again, the plaintiff may submit an order consistent with what the transcript says in this matter. And if there is a default, then that order should in fact address the action that should be taken by virtue of the default. That is an application for writ or something along those lines. Mr. Applebaum, wait a minute, Mr. Mason had something, and then I'm coming to you, Mr. Applebaum. Mr. Mason.
Right, Your Honor. I retract what I was going to say, but only thing, Mr. Applebaum is correct in terms of the 30 days. That was when my client was going to give up possession and turn in keys, which he's done. But going back to the original court's pronouncement just now, obviously it's consistent with what the judge's order was, and I will be submitting an order in that regard, as well as attaching as a proposed order my application for eviction in this case, Your Honor.
Right,
I would ask that Mr. Mason submit that under the 7-day rule. That would give my client an opportunity to either ask me to object to it or get new counsel to file a timely objection. I want to save Mr. Mason the time to file a motion for the entry of the order. It's been quite a while, and I think that's fair to all the parties.
Yeah, I mean, I think it's a reasonable way to do it. I guess my concern here is that there was never an order. There was never an order closing the case. So what probably should have happened here, was just the submission of an order under the 7-day rule.
Well, the challenge, Your Honor, is that the court did computer generated an order of dismissal in the case during the pendency. Yeah, that's what threw everything off, Your Honor. What I would have done, the court submitted and back in December, there was a dismissal that forced me to file a motion to reinstate.
Wow.
I know. So it just, and with the time involved, I know it's very interesting. So it just required, I thought it was an administrative issue based on workforces and things of that nature. So my ego is not that big. I didn't get upset. I just came back to the drawing board. But I do agree. My client has waited an inordinate amount of time in this case and is entitled to do justice, Your Honor.
All right, I'll review the order after its submission, counsel, and we'll sign it if there are not objections to the same. If there are objections, the court will address that as it arises.
And one minor thing, Your Honor, my client did have like some equipment and things that was part of the agreement in terms of just relinquishing all of that stuff in possession, but I will put that in the 7-day order.
Yeah. All right. So I'll put on the file that the matter is reinstated. The order dismissing that was issued in the month of November 2021 is set aside.
Thank you.
The court the court stands waiting for receipt of a 7-day submission.
Thank you, Your Honor.
Thank you. Thank you. Good day to the two of you.
Thank you.
Good day.
Goodbye now.
Be right with you, Mr. Washington, Ms. Jefferson.
No problem, Judge.
Oh, yeah. Okay. Just hold on. Keep those here.
Okay, yeah.
All right, and we're back on the record regarding the suffix 0013. That is Visiting Angels Living Assisting versus Kenneth Wesley. And Mr. Washington has previously entered his appearance on this matter. For defendant in this matter, also your appearance at this time.
Good morning, Your Honor. Thomasine Jefferson on behalf of Kenneth Wesley, P42872. Thank you.
Thank you, Madam Counsel. Mr. Frost, I'll be right with you, sir.
Very good.
So go ahead and update me regarding this matter. I know that there has been some efforts to try to get this resolved, but it seems to be that you might not quite be there at this time. Go ahead, go right ahead, Ms. Jefferson. Or, yeah, Ms. Jefferson, go ahead, talk to me.
Your Honor, we have gotten finally the information from the VA and we got all the income. We realized what was paid, what wasn't paid. According to our calculations, my clients, VA may owe about $1,400. We have talked to at least I talked to Mr. Washington on behalf of my client in the effort to kind of resolve the matter. We made them an offer and they haven't gotten back to it. That's where we at.
So do you Mr. Washington, you guys need to talk in the breakout room, or are you?
Well, Judge, I think I can give a little brief summary here. Here's Here's the situation that we're suggesting. We didn't hear from Ms. Jefferson until Friday, and today is the court date that's been set. Now, we're not doubting anything about what she's saying, except that we haven't seen anything, and that there has been an offer, which I've taken to my client. At this point, we would have to have some reservation about that, and we would suggest that if we're able to see the information, we'd have a better understanding of what it is. I talked to my clients, and what we're suggesting is that she says they've gotten with the VA, and if they've got proofs to show that it's credible, then we can deal with it. I think what would be appropriate, Judge, if we could just perhaps have I think we're to the point where if we had a trial date or something tentative to that effect, in the event that we can't resolve, we could probably save a lot of time than coming back and being in the same position. However, if what she has is credible and my clients are willing to accept, we would so notify the court and see if we can get this matter dismissed by way of just a paper presentation. But for all other purposes, Judge, in the event that we can't reach a settlement or we can't get close to where we should be, then we just ask the court to consider giving us some dates that we might be able to come back and proceed.
So, well, that makes sense to me, but here's the thing that I'm getting at is that we're going to set it for trial. I'm going to be setting that the next time I'll see you would be, somewhere between 6 and 8 weeks out. I'd like to see you in 2 weeks. I mean, if you think
Okay.
if you think that if you were near the finish line, I'd like to set a 2-week calendar. Just come back and let me see what's happening. I'll go ahead and set the trial then. I mean, it's
No, that's fair, Judge. 2 weeks out, I didn't know the court would be able to accommodate us that soon. But I think that's a reasonable proposition, and we'd be willing to try to see what we can do within that time frame.
Yeah,
I
that
agree,
makes
Your
sense.
Honor.
Yeah.
Yes.
I mean, I can always set the trial. I'll get it in as quickly as I can. But if 2 weeks might help to see exactly where things are, and I'll go ahead and set it over for a couple of weeks and pitch you in somewhere, and you update me and we'll find out where we are, and then we'll go from there.
Okay, Judge.
All right. So I'm going to go ahead and set it. In fact, I'll go ahead and put it on the 16th, 2 weeks from now.
Okay.
Let me check
So
that.
5/16, 22,
Let me see.
10 o'clock a.m.
Let's see.
If the 17th works better, I can do that.
I'm good either day.
Actually, okay, the 17th works better, Your Honor.
All right. So 5/17 at 10 o'clock a.m. Is the date set for reviewing this matter. And at that time, we'll get to the bottom line, and because you guys are close enough to whatever that is, and they'll make a decision regarding trial dates and dates of that nature.
Okay.
I think that's very fair, Judge, and
Right.
we'll do what we can within that time frame to see where we're at.
Thank you, Judge.
Thank you. Good day to the two of you.
Thank you,
too.
Judge. Have a good day.
Mr. Wesley, you can leave.
Okay, thanks. Okay. I can go.
Yeah.
All right.
For your patience on the suffix 5473, Be Right Financial Services versus Tramiel Rush. Thank you, Counsel. Thank you, Mr. Rush, for your patience in this regard as well. All right, Counsel, update me on where things are in this regard, sir.
Oh, yes, Judge, thank you. Mr. Rush and I have had a chance to speak, and we were able to reach an accord, a settlement agreement that we'll be putting into a form of an order and presenting to the court. It'll be a stipulated order. It'll basically be an order of settlement and for adjournment of the show cause hearing. And it'll provide that Mr. Rush will pay the reduced settlement amount of $4,000 in installment payments of $150 per month, commencing on June 15th, 2022, and continuing on the 15th day of each month thereafter until the settlement amount of $4,000 is paid in full, and upon payment of that amount, we'll file a satisfaction of judgment. However, if the amount, if he defaults in a payment, then we would be entitled to file an affidavit of non-compliance and renotice the show cause hearing for another day. And so I'll be emailing him a proposed stipulated order to that effect. And we expect to be presenting that to the court, Your Honor.
And Mr. Rush, you've heard the statements of Mr. Frost regarding a settlement in this matter for a reduced amount totaling $4,000 with monthly payments at $150 commencing June the 15th, 2022. Your compliance with those items would suspend any enforcement on any show cause, and it would result ultimately in a filing of a satisfaction of judgment that would close this case out upon the payment of that total sum. If you missed a payment, then the plaintiff would have the right to have the show cause reinstated, and also would have the right to have the full amount of the judgment as opposed to the reduced amount going forward. Is that your understanding of the nature of this agreement, sir?
Yes, sir.
And are you willing to go forward with such an agreement?
Yes, sir.
Anything you wanted to bring to my attention at this time?
No.
All right, so I will await the order that's going to be submitted to the proposed order that's going to be submitted to you, Mr. Rush, and then it will be submitted to the court. I'll sign it, and then it'll get back to you and to Mr. Frost as well. So I wish you well. Mr. Frost, I'm going to give you an email address where you can send that order once you're ready to go forward. That's at Latifah, LATIFAH dot last name Hunter at 36districtcourt.org.
Got it, Your Honor. We have that one.
Thank you. All right, I wish
We will
you
get-
well.
Very good. Thank you so much, Your Honor.
All right, all the best to you, sir. Thank you, Mr. Rush. Good day to the two of you.
Thank you. Bye-bye.